Hi, this is attorney Peter Lawrence with the law firm of Lawrence and Jerkevitz LLC with offices in Hartford, Avon, and Torrington, Connecticut. The topic of this screencast is reaffirmation agreements in bankruptcy. Reaffirmation agreements arise when you have a secured debt in your bankruptcy case, which most typically would be a mortgage on real estate or a car loan. Secured debts can also arise in jewelry and furniture and things like that, but we're going to focus on mortgages and car loans, but the rules are the same. The effect of signing a reaffirmation agreement is very significant. It means that a debt that would otherwise be discharged in your bankruptcy will not be discharged. Because it is a secured debt, the bank that had the lien making it a secured debt does not lose that lien. Now, that's really the focus of this screencast, so that you understand the difference between the debt and the lien or the collateral for the debt. And so we're going to come back to some of these essential points after, but it's really important that you understand the difference initially between those two types of lending. So we're going to move on right now and talk about the difference between secured debt and unsecured debt. Now let's talk first about an unsecured debt, and a perfect example of that would be a credit card. So here we have excuse me, a credit card, and here we have you. And the credit card transaction is really about as simple as it gets. In a credit card or unsecured transaction, what's happening is the credit card company, or more accurately the bank behind the credit card, is agreeing to lend you money. So the bank agrees that they're going to lend you money, and you in turn are agreeing to pay back that money. So we're going to call that a promise to pay. And that's pretty much all that's involved. Now, when you file a bankruptcy case and you obtain a bankruptcy discharge, the effect of that discharge is that your promise to pay is eliminated. And so that's the effect of the discharge. You no longer have a legal obligation to repay that debt. Okay, so that is an unsecured debt. Now, let's talk about a secured debt. So, with an unsecured debt, the transaction starts out in pretty much the same way. The bank is agreeing to lend you money. However, in a secured transaction, most often the dollars involved are significantly greater than in a credit card transaction. And so, in addition to requiring your promise to pay, which is no different than in the previous example, okay, you promise. However, in the case of a secured debt, the promise is not enough. The bank requires something additional, which is referred to as collateral. And in the case of a mortgage, the collateral would be your house, and in the case of a car loan, it would be the title to your car. So in the case of you're getting a mortgage on your house, either a refinance or a purchase, you are, in addition to making that promise to pay, you are giving the bank a lien on certain of your property. And in the case of a house, that lien is called a mortgage. And the same would be true in a car loan. It's done a little bit differently, that you're giving the bank a physical possession of the title, but in either case the bank has a security interest or a lien on this asset, which we refer to as collateral. Alright, simple enough. Now let's go back to the bankruptcy case, and in the case of a bankruptcy, the same effect obtains when you get your bankruptcy discharge. Your promise to pay is eliminated. However, these liens are not affected by the bankruptcy. So if you have a mortgage on your house, the bank still has a mortgage on your house after the bankruptcy, even after your promise to pay is discharged. And the same thing with a car loan. If you reaffirm a debt in bankruptcy, and we'll talk about the details and the mechanics of that in a minute, but if you sign a reaffirmation agreement, then the effect of the bankruptcy is reversed. Okay? So your promise to pay that would have been eliminated in the bankruptcy is revived. And it is just as if you had never filed bankruptcy with respect to that debt. And so now you are right back to where you started from prior to filing bankruptcy. The bank still has a lien on the house or the car, and your promise to pay is legally enforceable even after you file bankruptcy. So bankruptcy would have wiped that out. A reaffirmation agreement reestablishes or reaffirms that debt and makes it enforceable again after your bankruptcy. So why does this topic even come up? Well, it comes up because the bankruptcy code requires that when you have a secured debt, and you now understand what that is, the bankruptcy code requires that you state your intention regarding the property, the house or the car, securing that debt, and also the debt. Whether you intend to surrender the property, give it back, whether you intend to reaffirm the debt, or there's another option that we're not going to go into right now. And the final option is you can keep the asset and continue to pay for it without signing that reaffirmation agreement. Now, bankruptcy lawyers generally advise against signing reaffirmation agreements because in most cases the risk outweighs the rewards. If you have a house that's worth $200,000 and you owe $250,000 against it, which is not all that uncommon a scenario these days, if you reaffirm the debt and someday if you lose the house, the bank can pursue you for that extra $50,000. It's called a deficiency. Whereas you would have been protected from that if you had not signed the reaffirmation. The reason that banks argue a reaffirmation agreement is of benefit to you is because a debt that's been discharged in bankruptcy is not reported on your credit report, even if you're making payments on it. So if you're paying down the mortgage on a mortgage debt that was not reaffirmed, your monthly payments are not going to be reported, even though you are making payments and amortizing that down to zero eventually. That is a relatively small benefit relative to the risk involved in being back in debt on a large obligation immediately after your bankruptcy, when the original intent of your bankruptcy was to get you out of debt. This screencast is really intended to give you some background on a fairly complicated topic that is present in many consumer bankruptcy cases, because so many people have car loans, so many people have mortgages. So it's important that you discuss the details of your case with your bankruptcy attorney, and I hope that this screencast has given you a little bit of a better understanding of the background and a means to understand what a reaffirmation agreement is and its possible significance to you. Thank you.